All right, and continuing putting it all together, the next steps that I want you to do is number 5, search for relevant case law that will support your arguments. It's important to look for these particular case laws that will support what you're attempting to argue and the point that you're trying to get across. So let me also make this very clear. Every case law that you're looking up does not have to be in reference to child support. Sometimes it can be in reference to the overall thing that you're mentioning, which is due process violations. You may be able to find cases where they talk about the due process violation of not receiving a hearing for a car salesman at this particular instance. That can still be used for your child support case because the fact of the matter is due process wasn't met. There's also case law surrounding privacy law. There's constitutional rights. So find case law that will support your arguments. The next thing that I want you to do is find your way back into court. You have to find your way back into court. There's several different ways to do it. One of the best ways to do it is to put in a notice for modification. You're requesting a modification of your current payments. And the modification form you can get from the child support agency, that form is typically for the custodial, quote unquote, or the non-custodial parent. So they'll give it to you, you put in for modification, and you can select for decrease in payments, or you can ask for termination. Just depends on your state, how their paperwork is set up. But if you ask for a modification to have your payments be decreased or reduced, you're going to ask that they be decreased or reduced down to 0, and just have a strong case to support why you deserve to have that happen. The next thing you're going to do is number 7. You're going to file a motion for special appearance. So after you have your new court date, okay, you're going to file that motion for special appearance. Please do not wait till the last minute to file your special appearance motion. At the minimum, there should be at least 10 days between when you file and when you actually go to court, okay? So file that motion for special appearance. Remember, you can file it sending it through U.S. mail, via certified mail. That way they can't say that they never got the motion. And you can also file your motion directly with the clerk of court, all right? And the very last thing that you want to do is prepare your outline or your script. If you prepare an outline or a script, you're going to be able to do what these fake judges and these people on this administrative hearing team do. They run a script. It's the same thing all day, every day. So what you're going to do is interrupt that script by using your own outline and using your own script. And you go off of all the things that you're arguing. You're going to present that. You're going to present the case law, the United States codes or the state codes that support you. And any and every time they say something or they try to push past it, you can always object and you can redirect them to the area for which you want to talk about and have it settled. Do not give up on letting these people, do not give up on your fight. Don't let these individuals talk you out of your spot. Don't let them tell you that this case is not relevant or that argument is not relevant. If it's not relevant, then you have the right for them to give you tangible proof that what they're saying is actually true, as you have already provided the tangible truth when you found the relevant case law that points to your argument. They will have to show you something otherwise, okay? Make sure that you stick to your script and you don't avert from it, but always remain respectful, stay calm, stay poised, and if they decide to dismiss your hearing for the day, that's perfectly fine, as long as you always create the record. So make sure that when you're talking, you every now and again you throw in there, I would like the record to show. I would like the record to show. This is for the record. You do that and you'll have a solid case. Even if that hearing gets dismissed, you can always go back to court and you use your transcripts from the previous hearing to get you through. Now, guys, I hope that You have a clear understanding of how to bring this whole thing together. There's so many different pieces and variables to this whole situation of fighting child support, and it can be a little daunting. But literally, just go over these videos one by one. Go over these steps one by one. Create your outline. Do things in pieces. Don't do it all at one time. Fortify yourself now so that way when you're ready to go into the courtroom, you will be sharp as a tack and you'll win your case. With that being said, I'll see you guys on the outro video. Peace.